Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Hey fam, it's your girl, your favorite paralegal, aka Cassandra, and welcome to Legal Doc Talk. Hey y'all, so I I don't want to say I'm doing something different, but I think this is something that needs to be done. I have pulled the opinion that the 12th Court of Appeals out of Tyler, Texas, have issued in the appeal that Drew Anthony submitted. If y'all are unaware, Sarah Fields filed a lawsuit against Carmelo Anthony's father, Drew Anthony, Tiffany Billions, and Charleston White. And of the three, well, I said Charleston White, he ain't do nothing. Charleston claiming that's a whole nother different that's a whole nother different session. And Andrew filed a motion to dismiss in the trial court and it was denied. Shortly after denial, Drew immediately filed a notice of appeal. So it was in the appeals process for a minute. And I'm going to go over that with you guys in just a second. But Sarah Fields ended up filing that defamation suit and he was moving to get that dismissed. And there's just a number of things that he did procedural wise that I think that did not help him at all. I don't think he had I didn't look at it. I need to go look at the trial court records to see if he had an attorney or if he was just doing this pro se. And it appears he probably was doing this pro se because there's a lot of procedure stuff that he did not do. So anybody out there, you have some people that are awesome that know the system, they know how to work it, but then you have some that are new to this and there's certain things that you have to do, but whenever you are in doubt, look at the local rules for that specific court or that county, and you'll understand exactly how you submit things, what you need to do after you submit things, so on and so forth. So that way, you know that you're doing the right thing. But then also reach out to attorneys. You have legal aid and people out there that can probably assist you, especially when it comes to this matter. So if you're ever representing yourself, either reach out to legal aid. Well, in Texas, that's what we call it, legal aid, or just do your research. But before we get into this opinion that was issued, please hit the like button. Please share my video. And if you have not subscribed to my channel, please go ahead and do so. That way, anytime I go live or if I have another video, you guys can, get notification that something's going on over here on my channel. Y'all need to come check it out. But without further ado, let's hop on into this. Now, before I get into anything, I do want to, I treat this like class because, before I'm a paralegal, I'm an educator. So I want everybody to understand what some of this stuff means. So if you hear these terms, this is what it means. So TCPA, that's the Texas Citizen Participation Act, the Texas anti-SLAPP law designed to dismiss lawsuits that target protected speech early in litigation. Prima facie case, that is the minimum evidence necessary to support a rational inference that the claim is true. Vicarious liability, being held legally responsible for the actions of another party. Doxing, everybody know what doxing is, posting the non-consensual online posting of someone's personal information for the purpose of harassment. And then swatting, making a false emergency report to law enforcement to trigger a police response at someone's address. Okay, these are some of the things that they list in the opinion. Now I'm going to tell you guys this. When we get to this opinion, please, 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 there are some words that I have no clue about. Okay, as long as I know how to do my stuff on a daily, I don't care. If I need to learn it, I learn it. If not, hey. But so I just want to apologize right now if I stumble over some words. This is a 15-page document, and I'm going to try to get through it so you guys can just get a picture. I'm not going to give my opinion on anything. I want you guys to understand what the Court of Appeals wrote, what their opinion was, and you formulate your own conclusion, your own opinion, or you make your own inference. I can't tell you how to do those things. The only thing I can do is I can present the document to you, read it, and however you interpretate that or comprehend that, that is on you. Okay? Do with the information as you will. If y'all know me, if y'all been with me, y'all know I get my stuff straight from the court websites or Westlaw. I don't pull it from nowhere else. And I try to do it on live or on this video, as y'all can see, so you know that it's not being tampered with in no shape, form, or fashion. This is the docket for this case, as you can see, Drew Anthony versus Sarah Fields. And once again, it's the appeal because his motion to dismiss was denied by the trial court. And this is out of Smith County. Let me see. All right. So, and also, if you've been following this case and if you actually tuned into I don't know if I did a video or a reel. But I explained the appellate process. Actually, I did both, but I kind of explained the appeals process so you guys can understand how it works. Okay. Now, as you can see, this is a docket. I'll give you a few seconds to kind of go from the bottom up to kind of see what all is issued. So I'll give you about 10 seconds. All right. So notice of appeal is filed with the trial court. That notice of appeal is sent up to the assigned appeals court. The appeals court go ahead and issue to all parties and counsels of record. Once that notice of appeal is filed, that starts the proceeding for the appeals process. Once that notice of appeal is filed, the next step is to order all of the clerk's records and the court reported transcripts, and they have to submit it to the Court of Appeals. The Court of Appeals then issues those documents to the appellant and appellee. First thing first, the appellant, well, before we even get there, a docketing statement is filed. And that has all the information on there, the judgment of the lower court, if there were any related matters, the parties' information, the attorneys, if they have that, so on and so forth, okay? Then, once that docketing statement is filed, then that kicks the date for the appellant, who is Drew Anthony, to have his brief due. Once he gets his submitted, then that kicks the date for the appellee to have their brief due. Now, as you can see at the top, both of them submitted their briefs, but they did not do a requested oral argument. Because if that was the case, once the brief is done, they have to do oral arguments, and then the judge will give their opinions. But oral arguments were skipped, so the briefs were sent to the judge, the panel. It's a minimum of 3 in Texas. And they reviewed everything that was submitted in the briefs, right? Everything, along with all of the court records and the transcripts. They reviewed it and they formed their opinion. Got it? All right. Now I am going to pull this document so you guys can see that it's not altered. Hey. Okay. So here Now, it does show on here that it was affirmed. So that does mean that the appellate court did agree with the trial court denying Anthony's motion to dismiss himself from the lawsuit. But you will understand once I read the opinion as to why. It's very important that you understand if you are going to appeal, that you understand what you are appealing and how to appeal it. Okay? I have a whole guide. So if you are ever in need to appeal a case in the state of Texas, I don't know about anywhere else, but in the state of Texas, the Texas Young Lawyers Association they have a guide that you can follow step by step. But let's go here. Like I said, I am going to read this. I already gave you guys the terminology. If you have questions, definitely put them in the comment area and I'll try my best to answer them. But I'm going to get through this because it's 15 pages. So let's go. Drew Anthony's appeals this trial court's denial of his Texas Citizen Participation Act TCPA motion to dismiss the lawsuit filed against him by Sarah Fields. In three issues, he challenges the trial court's denial of the motion to dismiss under the TCPA and contends he is entitled to attorney fees and costs and sanctions against Fields. We affirm. Karmelo Anthony, now age 19, was tried for murder in Collin County for fatally stabbing a fellow high school student during a high school track meet in 2025. This incident and its associated trial became a media sensation. TikToks, podcasts, YouTubes, and other social media. Fields, a self described independent journalist reporting on matters of the public interest, reported on the incident and matters leading up to the trial. Fields sued Karmelo's father, Drew Anthony, alleged spokesperson and advocate for the Anthony family, Tiffany Lynn McAdoo, Tiffany Billions is better known as, and Charleston White for defamation per se, defamation, intentional infliction of emotional distress, invasion of privacy, public disclosure of private facts, civil conspiracy, and negligence per se, false report to law enforcement and CPS. Fields alleged that Anthony appeared on McAdoo's public TikTok live panel on November 22nd, 2025, and made false statements accusing Fields of doxing Anthony and his family. Fields further alleged this did not occur. Fields also alleged that Anthony selected McAdoo as his family spokesperson and advocate, and that Anthony, White, and McAdoo acted in concert with each other to harm Fields through their coordinated campaign of defamation, harassment, and false reporting, and harm was caused by this reporting, including a swatting incident and false CPS reports. Fields further alleged that McAdoo utilized X and a public TikTok live panel and is the leader of what she calls the Disruptors, a group of activists who go after anyone who disagrees with her position on issues related to Karmelo Anthony case. Allegations as to McAdoo's conduct include accusations that Fields committed various crimes, statements that Fields is a drug addict, whore, crackhead, meth head, and crack whore, doxing Fields' personal information, and falsely reporting to authorities resulting in swatting. Fields further alleged McAdoo encouraged and applauded the use of false reports of child endangerment to Child Protective Services against Fields, and that while Fields was in labor, CPS arrived at Fields' house based on defamatory statements put out there by defendants. Anthony answered and asserted a general denial, various affirmative defenses, and a Rule 91A motion to dismiss. Of the three defendants, only Anthony moved to dismiss under the TCPA. He argued that dismissal was appropriate because Fields claimed to seek to chill protected speech on matters of public concern without any valid legal foundation. Specifically, Anthony asserted that Fields' claims are defamation related and thus invoked the TCPA. He further asserted that Fields' claims arise from a statement regarding a matter of public concern for purposes of TCPA because they were made on a public forum of TikTok and related to Fields' reporting on the Karmelo Anthony case, which was the subject of intense online and public discussion. Anthony alleged that Fields did not have the clear and specific evidence to a prima facie case for each essential element of her claims as required to survive a TCPA motion to dismiss. Fields did not request discovery under TCPA Section 27.006b. Fields responded to the motion and attached one, a pro se court pleading from Collin County, in which McAdoo moved to recuse presiding Judge Roach, and a USB flash drive. So, based on that motion, it's saying that, and you guys will see in a minute, there's three things that has to be done in order for them to even consider it to be dismissed under TCPA. But hold on a second. After the hearing, the trial court denied the motion to dismiss without specifying a particular ground. The court denied Anthony's request for finding of fact and conclusions of law. This appeal forwarded. And I'm wondering if I should have looked at that before, but I'm wondering if they dismissed it with prejudice or without prejudice. The TCPA motion to dismiss. We consider, okay, so in this section, guys, how can I say this in the simplest terms? So it's going to describe what the court appeals judges did, and they're going to quote case law in which they're going to tell you what they did, but they're going to tell you why they did it and where they got that idea from. I think that's probably the most perfect way to explain that. Okay. All right. So let's get into this section. And once again, this is the TCPA motion to dismiss. So we considered de novo the legal question of whether the movant, which would have been Drew Anthony, established by a preponderance of evidence that the challenged legal action is covered under TCPA. So we have, they quoted that from Baylor Scott and White versus Project Rose and Media One LLC versus Henderson. They also reviewed de novo a trial court's determination of whether a non-movant, which would be Sarah Fields, presented clear and specific evidence establishing a prima facie case of each essential element of the challenged claims. Similarly, we review questions of statutory construction de novo. We review the pleadings and the evidence in the light most favorable to the non-movant. We do not blindly accept a movant's attempt to characterize a non-movant's claims as implicating protected expression. Instead, we favor the conclusion that the claims are not predicated on protected expression. Pursuant to Section 17.003b, a motion to dismiss a legal action under this section must be filed not later than the 60th day after the date of service of the legal action. The statute requires a defendant seeking its protections to move for dismissal and obtain a hearing on the motion within certain clearly defined periods. The failure to meet these requirements result in the defendant forfeiting the statute protections. The TCPA's statutorily expressed purpose is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time protect the rights of a person to file meritorious lawsuits for demonstrable injury. The statute serves this dual purpose by authorizing a motion to dismiss early in the covered proceedings, subject to expedited interlocutory review. To accomplish this objective, the TCPA provides a three-step process for the dismissal of a legal action to which it applies. First, the movant must demonstrate the legal action is based on or is in response to its exercise of the right of speech, petition, or association. Second, if the movant meets that burden, this first step here, if they meet that first step, the non-movant, which is Sarah, may avoid dismissal by establishing by clear and specific evidence of prima facie case for each essential element of claim in question. Finally, if the non-movant satisfies that burden, the court still must dismiss the legal action if the movant establish an affirmative defense or other grounds on which the moving party is entitled to judgment as a matter of law. This is how the TCPA is applied. In Anthony's first issue, he contends that the TCPA applies to Field's claim because it is based on or in response to Anthony's exercise of the right of free speech. So here's his exercise of the right of free speech. Anthony was required to demonstrate that Field's legal actions are based on or in response to Anthony's exercise of the right speech. The TCPA is required based on nexus if is satisfied at minimum for legal actions that are factual, predicated on allegations of conduct that fall within one of the TCPA's protected rights. The level of nexus required includes no qualification as to its limits and is very broad. A plaintiff's claims are in response to a protected activity when they react to or are asserted subsequently to the communication. An exercise of the right of free speech means a communication made in connection with a matter of public concern. A communication is defined broadly as the making or submitting of a statement or document in any form or medium. A matter of public concern includes a statement or activity regarding a person who has drawn substantial public attention due to the person's fame, notoriety, and celebrity, a matter of or interest to the community, or a subject of concern to the public. Texas courts have interpreted this phrase to mean that the statute requires only that the communication have a tangential, I hope I'm saying that right, relationship to such a matter, and the connection need not be more than tenuous or remote. The TCPA does not require that the communication specifically mentions a matter of public concern or have more than a tangential relationship to such matter. Rather, the TCPA applies so long as the movant's statements are in connection with any of the matters of public concern listed in the statute. In determining whether TCPA is applicable, we conduct a holistic review of the pleadings. Our analysis is not constrained by the precise legal arguments or record references made by the moving party regarding the TCPA's applicability. Rather, our focus is on the pleadings and on whether, as a matter of law, they are based on or in response to a matter of public concern. In the final analysis, when it is clear from the non-movant's pleadings that the action is covered by TCPA, the movant need show no more. For a movant to trigger the TCPA's dismissal framework, there must be a communication as defined by Section 27.001, Paragraph 1. Neither party challenges whether the statements at issue constitute communications. Because a lawsuit involves claims predicated on more than one communication, we must consider each in determining whether Anthony satisfied his burden that the communications were made while exercising his right of free speech. So now we're going to take a look at the statements that are at issue. Here, there are numerous overlapping statements at issue. and 6 causes of action. For each cause of action, Fields realleges all statements as a basis for the causes of actions. And remember, the causes of actions is the what defamation per se, defamation, civil conspiracy, negligence, all of that. Okay. So here are the direct statements. The relevant categories of statements are as follows. So it's broken up. We have Anthony's statements that he made on the TikTok live, and then we have McAdoo's statements. Okay. So direct statements that were made by Anthony on the live panel. We're not talking about text messages or anything of that nature. We are talking about the TikTok live. That's the reason they are being sued. Okay? It's not for text messages. Well, I mean, he probably messaged her, but we'll get into that. Direct statements. Anthony's direct statement regarding what Fields' reporting has done to his life. Anthony's direct statement regarding Fields' doxing of his home address. So those are statements that came out of his mouth. McAdoo's statements with alleged agency of Anthony. McAdoo's name calling statements made on TikTok and X, calling Fields a meth head, whore, crackhead, crack whore, and drug addict. McAdoo's doxing statements made on TikTok and X, Fields' home both by photo and address and full name of oldest daughter. McAdoo's change.org petition, using a false identity to create a petition seeking review of Fields' parenting and related promotion communication, including Fields' 2012 arrest docket as support. False reports to authorities resulting in swatting. Public encouragement, promotion, and celebration of false reports of child endangerment to CPS. August 24th, 2025, false report to law enforcement by McAdoo or another at her assistance, which resulted in swatting Fields' home on that same date, and a false report resulting in an event on August 25th in which CPS arrived at Fields' house based on defamatory statements put out there by defendants while Fields was in labor. McAdoo's accusation that Fields is harassing Anthony. McAdoo's accusation that Fields neglects and mistreats her animals, and public encouragement, promotion, and celebration of the idea of her followers making false reports to animal control authorities to have her dog removed. McAdoo's accusation that Fields committed the crimes of tampering with evidence, witness tampering, obstruction of justice, civil rights violations, insider access to gain private information from the Collin County Courthouse, and wire fraud. Each statement is analyzed to determine whether it pertains to Fields' reporting on the alleged criminal act of Karmelo Anthony, the murder trial, or other critiques of Fields' reporting. Now, this is how TCP applies to the direct statements made by Anthony. First, we determine whether Fields' legal action against Anthony is based on or in response to Anthony's exercise of his right to free speech on a matter of public concern. Fields complained of Anthony's direct statements as follows. Anthony appeared on a live TikTok panel on November 22nd, 2025, and told the host that y'all don't really know how much effect Fields' reporting has done to my life. But wait, time is going to tell, I promise you. Anthony, falsely stating that he begged Fields to stop sharing his address or doxing him and his family, knowing that no such communication ever occurred because Fields never shared Anthony's address. The only communications that Anthony sent to Fields were for him asking her to stop reporting on the case because he claimed her reporting was harassment, which she declined. McAdoo then asked Anthony, so what you are saying is that she knew she had Doc's job because you had told her? And Anthony said, yes, I told her 100%, 100%. This statement is false. And Anthony knew the statement was false. No discussion occurred. So this is okay, so Field complained of Anthony's direct statements as follows. So this is what she said had happened. So she's saying she never shared his address. She only got communications from him asking her to stop reporting on the case, and she said no. And let me see. McAdoo then said, Anthony, so what you are saying is that she knew she had Doc's job because you had told her? Anthony said, yes, 100%. Sarah is saying that that statement was false and that Anthony knew the statement was false. He never had a discussion with her about the doxing of his address. Okay. These same statements were realleged in support of Field's cause of actions for defamation per se, defamation, intentional infliction of emotional distress, invasion of privacy, public disclosures of private facts, civil conspiracy, and negligence per se, false report of law enforcement CPS. Anthony contends that TCPA applies to these statements because Field's legal action against him is based on or in response to Anthony's exercise of his right to free speech on a matter of public concern, and the Court of Appeals, those judges agree about that. Anthony's statements occurred on McAdoo's public TikTok forum. Social media posts receive the same TCPA protection as other forms of communication when they are addressed matters of public concern. These statements involve Anthony's assertions critiquing Field's public reporting about his son and his family in connection with the alleged murder. Fields is a self described independent journalist who reports on the matters of public interest. Public matters include, among other things, the commission of a crime, prosecutions resulting from it, and judicial proceedings arising from the prosecutions. Anthony discusses the effect of Fields' reporting on his life and agreed with McAdoo that he asked Fields to stop sharing his address and doxing him and his family. Anthony's statements bear a tangential relationship to a matter of public concern because the statements pertain to Fields' public reporting on his family. Again, the TCPA does not require that the communications specifically mention a matter of public concern or have more than a tangential relationship to such matter. Rather, the TCPA applies so long as the movant's statements are in connection with any of the matters of public concern listed in statute. We conclude that the TCPA applies to Anthony's direct statements. And my reel pretty much sums all of this up. And I'll read that afterwards so y'all can get a general understanding of what this opinion is saying. But I just want to read it so you guys can understand why it went the way that it did. All right, so here's the Prima facie case. Having determined that TCPA applies to Anthony's direct statements, we now determine whether Fields presented clear and specific evidence to support the challenge causes of action. So remind you, the TCPA has those 3 steps. All right. So now the plaintiff got hit. Well, not the plaintiff. The movement had the first part. Now this is the second part where you have to present specific, clear and specific evidence. All right. So this is where we at, the Prima facie case. Anthony contends that because Fields presented no evidence whatsoever to the trial court in response to the TCPA motion, she failed to meet her step 2 burden and her claims must be dismissed. On appeal, Fields does not attempt to argue that she made a prima facie case for any of the 6 causes of action she alleged. Instead, Fields contends that she had no obligation to present evidence because the trial court ruled on step 1. In determining whether a legal action is subject to or should be dismissed under the chapter, the court shall consider the pleadings, evidence of the court could consider under Rule 166A of the Texas Rules of Civil Procedure, and supporting and opposing affidavits stating the facts on which the liability of defense is based. In general, for purposes of issue preservation for appeal, a trial court's ruling on an objection to a summary judgment is not implicit in the ruling on a motion for summary judgment. Summary judgment evidence must be admissible. To defeat Anthony's motion to dismiss, the TCPA requires Fields to establish by clear and specific evidence a prima facie case for each essential element of her claim. Clear means unambiguous, sure or free from doubt, and specific means explicit or relating to a particular named thing. A prima facie case, is the minimum quantum of evidence necessary to support a rational inference that the allegation of fact is true. It refers to evidence sufficient as a matter of law to establish a given fact if it is not rebutted or contradicted. To meet the clear and specific evidence requirement, a plaintiff must provide enough detail to show the factual basis for its claim. The TCPA does not require direct evidence of each essential element of the underlying claim to avoid dismissal. However, conjecture, guess, or speculation cannot survive clear and specific scrutiny under the TCPA. Further, the response must be supported by admissible evidence. The supporting evidence can include pleadings, affidavits stating the facts that the defendant's liability is based on, and other evidence that the court can consider under Texas Rule of Civil Procedure 166A. Although the court can consider the plaintiff's pleading and ruling on the motion to dismiss, pleadings alone are insufficient to satisfy the plaintiff's prima facie burden. As explained in Busby, accepting all allegations as true for purposes of establishing a prima facie case without demanding evidence that is legally sufficient to establish the allegations as factual true if it is not countered would nullify the very purpose of the TCPA's burden shifting mechanism. At the trial court level, Fields responded to the motion and attached 1. A pro se court pleading from Collin County in which McAdoo moved to recuse presiding Judge John Roach, and 2. A USB flash drive. The court pleading filed by McAdoo contained an unsworn declaration in writing and subscribed as true under penalty of perjury, but lacked McAdoo's address and date of birth. The USB drive contained 2 videos and was not authenticated. Anthony objected to the lack of authentications before the hearing, but did not obtain a ruling on the objection. In the past, we've acknowledged that given the early stage of litigation, the evidence presented by the non-movant under the TCPA motion to dismiss need not necessarily present the best evidence to satisfy this burden. However, in Baylor, Scott, and White, there was at least an unsworn declaration in writing and subscribed as true under penalty of perjury. So McAdoo's unsworn declaration, she submitted it, but she didn't have her address or anything of that. So when you submit motions, you have to, like, on the attorney wise, we got to have the state bar number, address, phone number, all that. So if you're missing that information, they're going to either kick it back, or sometimes you might have to call the court. Then they'll finally, and it actually the file clerk, because when we file it, the file clerk going to look and make sure everything is on there. So that's going to be done even before it gets to the court. But that's neither here nor there. Here, we are faced with similar circumstances and determine that McAdoo's unsworn statement is not fatally deficient. However, this evidence is largely irrelevant to her claims. Within this document, McAdoo states, also known publicly as Tiffany Billions, is a well-known community activist who is actively, prominently, and publicly advocating on behalf of Karmelo Anthony. While this is potentially some evidence of agency on behalf of Anthony, there is no other substantive evidence within this document that could support any of Field's 6 claims. Further, there is no thought authentication of any kind for the USB drive. While we are not aware of any cases addressing whether failure to authenticate is a defect or a substance in TCPA context, we follow analogous and well-established summary judgment evidence authority and conclude that complete lack of authentication is a defect of substance and no objection is necessary to preserve error. Let's see. Accordingly, we hold that because of the total lack of evidence that the court could consider under Rule 166A, there is no proof that the court can consider under TCPA. As to Anthony's direct statements, Fields failed to make a prima facie case as to each essential element of Fields' causes of action. Anthony's first issue is sustained in part. Now let's apply the TCPA to McAdoo's statements. First, we address Anthony's arguments that the pleadings do not sufficiently raise theories of respondent superior or agency for McAdoo's statements. We disagree. We note that although Anthony's answer included a Rule 91A motion to dismiss, Anthony did not specially accept to Field's petition, and Anthony never set the Rule 91A motion for hearing. Anytime you file a motion in the court, you have to set it for hearing. And 9 times out of 10, anytime you file a motion, you need to also ensure that you file a proposed order. Let's see. Where was I at? Okay. Oh, and back to this part, where it says Anthony direct statements, Fields failed to make they said that this issue is sustained in part. That means that they agree with only a portion of it. Okay. Let's see. Absent special exceptions, we will apply the fair notice pleading standard. Thus, our procedural rules merely require that the pleading provide fair notice of the claim and the relief sought, which that the opposing party can prepare a defense. With specific regard to TCPA cases, the Supreme Court explained, can't even talk. A pleading must give fair notice not just of alleged facts, but of the claim and the relief sought such that the opposing party can prepare a defense. And ascertain from the pleading the nature and the basic issues of the controversy and what testimony will be relevant. Providing only fair notice of factual allegations does not provide fair notice in claims or causes of action asserted based on alleged facts. Here, Fields allege Anthony has selected McAdoo as his family spokesperson and advocate. Defendants acted in concert with each other to harm Fields through her coordinated campaign of defamation, harassment, and false reporting, and harm was caused by this reporting, including but not limited to the swatting incident and the false CPS reports. Anthony defended McAdoo's actions in representing him, saying that McAdoo's is a beast at putting stuff on other people, clearly indicating support for and in furtherance of his objective to harm Fields through McAdoo and her disruptors. And one thing I do want to say is that us Black folks, we have a language, and sometimes when we say things, people misinterpret it. So is a beast that putting stuff on other people, I don't even know how they took that, and I'm throwing that out there. Further, Fields alleges a cause of action, a civil conspiracy claim against all defendants. To recover for civil conspiracy, a plaintiff must prove the following essential elements. One, defendant was a member of defendant was a member of a combination of two or more persons. The combination's object was to accomplish either an unlawful purpose or a lawful purpose by unlawful means. The members had a meeting of the minds on the object in course of action. One of the members committed an unlawful overt act to further the object or course of action. And five, the plaintiff suffered injury as the proximate result. We hold that this pleading provides fair and adequate notice that Fields pleaded a claim in which Anthony is vicariously liable for McAdoo's statements as his family's spokesperson and advocate, such that Anthony can ascertain from the pleading the nature and basic issues of the controversy and what testimony will be relevant. We next turn to Anthony's step one burden to establish the McAdoo statements on his behalf were communications in connection with a matter of public concern under the TCPA. Again, as the movant, it is Anthony's burden to demonstrate that the legal action is based on or is in response to the exercise of the right of speech, petition, or association. This only requires raising the argument in an examination of pleadings, which are the best and all sufficient evidence of the nature of the action. Even though the burden is not a heavy one, there is at least minimum burden to raise the argument or forfeit the protection of the statute. For example, in McElroy, wife sued her deceased husband's parents for harassment and stalking because they complained to CPS and the police about her treatment of the children. The grandparents filed a motion to dismiss under TCPA. Our sister court held that the grandparents discharged their burden by simply making their argument in the motion that the petition specifically strikes at movants' right to speak freely, to speak and confer with governmental agencies charged with the protection of children, and to petition the courts. In Anthony's motion, he made no attempt to argue to the trial court how McAdoo's statements were communications in connection with a matter of public concern. Anthony instead argued McAdoo's statements are not attributable to him, that he should not be lumped with other defendants, and that Field's own petition fatally undermines any claim against Anthony by attributing the actual disclosures exclusively to McAdoo. So the judge, they're telling you exactly what he didn't do and what he did do, thus the reason this wasn't favorable to him. In his motion, Anthony never contends that McAdoo's statements involved a right to speak freely or speak and confer with governmental entities, or that they regard in some other way a matter of public concern. By failing to make that minimum showing, the burden never shifted to Fields to make a prima facie case regarding Fields' causes of action based on McAdoo's statements. So remember, there was three parts of the TCPA, right? He never, when it comes to McAdoo's statements, remember you had his direct statements and then you had McAdoo's statements. And so he went on and on and on and on. But he never went past that first step when it came to McAdoo's statements. And the court just told you. They said by failing to make that minimum showing, the burden never shifted to Fields to make a prima facie case regarding Fields' causes of action based upon McAdoo's statements. So we conclude that Anthony failed this one-step burden regarding his vicarious liability for McAdoo's statements. And what is vicarious? sorry, pulling it up right here. Being held legally responsible for the actions of another party. So, again, it says we conclude that Anthony failed to satisfy his step one burden regarding his vicarious liability for McAdoo's statements. So they agreed with that the TCPA, that his direct statements was covered by that statute. But as far as McAdoo's statements, they weren't. He failed to satisfy because what his argument was, I can't control nobody, what anybody else is, what anybody else say, instead of saying her communication or her statements was a matter of public concern. Accordingly, we overrule Anthony's issue one in part. We sustain Anthony's first issue in part to the extent it relates to his direct statements, and overruled Anthony's first issue in part to the extent it relates to his vicarious liability for McAdoo's statements. Because the causes of action remain viable as to Anthony's vicarious liability for McAdoo's statements, we hold that no cause of action be dismissed. Because the TCPA permits dismissal of causes of actions, not statements, the judgment of the trial court is affirmed. So it's not changing. So he cannot be dismissed from that lawsuit. He cannot be dismissed from that lawsuit. So now the lawsuit against him, Charleston White, and who is that? Tiffany Billions will now proceed. They will now proceed. It's very interesting how everything changes in the blink of an eye, right? Anytime you are unsure about how to go about a case, I always tell, like, as a paralegal, I can't guide you. I can't give you any guidance. I can't give you any legal direction. Anytime somebody asks me, well, how can I do this? My best bet, what I tell them to do, you need to consult with an attorney. Sometimes they can't afford an attorney. So I then say, okay, you need to reach out to legal aid. Sometimes they say, well, I reached out to legal aid and legal aid told me that they can't help me. Okay, where your best thing to do is your own research. If you care enough about your case, you are going to put in the work in order to, you know, you're going to put in the work to ensure that you're going to do everything in your power to do the right thing. But just worthy advise, if can't nobody help, do your research. Start with the local rules from that court, and then Google is free. Google is free. So to kind of clear up everything, I want to just really sum up everything. And this is a summary. This is what I put on my reel. So I'm going to say, okay, so TCPA has a framework. They have 3 steps. Step 1, the defendant shows the lawsuit is based on protected speech on a matter of public opinion. If they do that, then the plaintiff then has to come forward with clear and specific evidence of the prima facie case. Step 3, even if the plaintiff does that, the court can still dismiss it if the defendant proves an affirmative defense. Okay, so I'm summing up exactly what happened in that opinion, or what was stated in that opinion. On Drew's own direct statements, the court agreed that the TCPA applied, but Fields barely submitted any admissible evidence in response. So a USB drive, it wasn't authenticated. The court pleading had no, it was totally irrelevant to her claims. The court said that was not enough. So he won that argument. He won that argument. But when it came to what McAdoo said, Sarah already said or alleged that Drew was vicariously liable. He was liable for what came out of her mouth. So in his motion, he argued that the statement shouldn't even be attributed to him. He should have argued that her statements was a matter of public concern because everybody was talking about the Karmelo Anthony case, his son, the family. So because he argued about the wrong thing, the appeals court said, okay, the rule for the lower court is going to stand. So they didn't dismiss the case. No attorney fees was awarded to Drew, and there was no sanctions filed against Sarah. So the case is now going to move forward. So because of that, in my opinion, if he did not say, hey, I can't control what another person say, if he would have said, well, her statements is part of public concern, he may had a good opportunity to get this, that to get dismissed from the case, I should say. So it's all about, you see how that one little mistake cost him the whole appeal. But I just want to get this out to you guys. Y'all let me know what y'all think about this in the comments below. Hey, keep it cute in the comments because I do read them and I do not mind banning anybody who is racist and who is downright disrespectful. Everybody's opinions are welcome on my channel as long as we keep them respectful. We can all agree to disagree. But until then, you guys be blessed. Bye.